pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Georgette, may we have a roll call?
Ms. Phillip,
Here.
Mr. Haber,
Here.
Mr. Mardy,
Here.
Ms. Tondreau,
Yes.
Mr. Mondesir, Mr. Nassib, Mr. McDermott.
Okay, thank you. Ms. Martin, would you make the announcement to the audience, please?
Good evening and welcome to the Board of Adjustment meeting. When your case is called, please come to the microphone and state your name and address for the record. Staff will make its presentation to the board first, after which you will have an opportunity to address the board.
Okay. And for anyone who will be speaking on any items this evening, whether for or against, our attorney will have to administer the quasi-judicial oath.
Anyone wishing to speak this evening, please stand and raise your right hand. Do you swear or affirm that the testimony you provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated.
There's some people outside.
There are people
Are they fine?
in the lobby that
Then, if they're going to speak this evening, we'll have to represent the oath. Yes. Thank you.
Ms. Martin, any amendments to the agenda?
No.
Okay. Any communications?
Board members, any communications concerning any of the evening's agenda? None? Okay.
Do I have to do a formal request to add the last suggestion I just made for the agenda tonight?
Would you like to add it to tonight's agenda or an upcoming agenda?
Well, do we have to set a date for us to vote on
Yeah, we
the
have to.
principle whether or not it's okay to do so?
Can we look that under
Can
no?
we do have it like, I think we should have
We can take that, perhaps may have that discussion. Let's say new business
New business.
in the agenda?
Yes.
Yes, that's what I would recommend.
Okay.
Yeah.
New
Thank you.
business. Thank you.
Okay. All right. Continued petitions.
There are none.
Okay. Let's start with our first new petition, V10-12.
Andrew
Oh, excuse
and
me.
As a point of order, Madam Chair, I would
Yes.
recommend.
Rise up.
Okay.
Approval of the minutes.
Thank you.
Yeah, that's not the part that I usually do. Okay. May I have a motion to approve minutes from August 15th? Thank you. Moved by Mr. Haber, second by Mr. McDermott. All those in favor? Aye. Any opposed? All right, our first new item, V-10-12. Andrew and Diane Shapiro.
please come forward and state your name and address in the microphone for the record.
Good evening, Ryan Bayline with offices at 150 West Flagler Street, here on behalf of Mr. and Mrs. Andrew Shapiro.
Okay, this is a petition for appeal of a decision on an application for administrative variance allowing for a rear yard setback of 20 feet where 25 feet is required at 2095 Northeast 121 Road pursuant to Article 3, Sections 3-604 and 3-702 of the Land Development Regulations in the R1 District. Staff recommends denial of the appeal of staff's approval of an administrative variance to allow a rear yard setback of 20 feet where 25 feet is required. An application for administrative variance was filed by the property owner of 2095 Northeast 121 Road and was approved by staff on August 21st, 2012. Consistent with Section 3-604C of the Land Development Regulations, letters were sent to the surrounding property owners advising them of the administrative decision to grant the variance and of their right to appeal that decision within 10 working days. The administrative variance was to allow a rear yard setback of 20 feet for a new residence where 25 feet is normally required. The applicant purchased a bayfront lot with plans to demolish the existing one-story, 3,500 square foot residence and build a two-story residence with 7,600 square feet of living area. The design of the new residence reorients the structure so that the pool and views face Biscayne Bay instead of the canal and the large condominium across the canal. Section 3-604A of the LGR states that an administrative variance may be granted by the Building and Zoning Department for a single-family duplex, triplex, or townhouse project for a variance to the setback requirements where the setback is not decreased by more than 20% of what is required in the zoning district. Such a setback variance could be applicable to a front, rear, or side yard setback. Section 3-604B of the LDR states that the granting of the administrative variance shall be based on the following. The variance is in harmony with the character of the immediate neighborhood and is in keeping with community goals as they relate to quality of life. And the variance will not adversely affect or be injurious to the adjacent uses, immediate neighborhood, and the community as a whole. In addition, Section 3-604E of the LDR states that appeals of decisions on an application for an administrative variance may be taken to the Board of Adjustment in accordance with the provisions of Section 3-702. The property owners of 2089 Northeast 121 Road are appealing the staff decision to approve the administrative variance to allow a rear yard setback of 20 feet. Their property is adjacent to and west of 2095 Northeast 121 Road, which is the subject property. The appellants stated in their letter that they do not believe the variance is in harmony with the immediate neighborhood, as all the houses on the northeast side of 121 Road have a setback of at least 25 feet. They further stated that the variance will negatively impact their quality of life and enjoyment of their property by unnecessarily reducing their view of Biscayne Bay, and the variance will cause injury to them through a decrease in the value of their property due to the reduced view of the bay. It is staff's opinion that the variance is in harmony with the character of the immediate neighborhood, as the trend is to build much larger and ultimately more expensive homes than were built in the 1960s and 70s, especially on lots that command a premium price due to their size and/or location. The administrative variance that was granted for this setback is in keeping with the goals of the land development regulations, which is to allow administrative approval of minor deviations from setback requirements, whether it be in the front, side, and/or the rear. In the case of the subject property, the rear yard encompasses both the canal side and the bay side for approximately 225 feet. The lot is long but does not have the depth that the interior lots on the block have. Furthermore, many administrative variances have been granted to allow for additions in the rear of the property to a 20-foot setback, including in the R1 residential estate district where the subject property is located. Other more extensive variances have been granted by the Board of Adjustment where the requested rear yard setback is less than 20 feet, including in the R1 residential estate district. Staff does not believe that the variance will adversely affect or be injurious to the adjacent uses, immediate neighborhood, or the community as a whole. In fact, the construction of a new, larger home will not only increase the value of the property the house is situated on, but will also increase the values of the surrounding properties. With regard to the view to Biscayne Bay, the house in question currently has a setback of 23 feet 3 inches as the closest point to the property line. The new house is proposed with a setback of 20 feet. Just as the appellant's house is built further to the rear than their neighbor to the west, the relatively minor variance will not take away from their view. Their view of the bay is quite substantial considering that they do not have a bayfront property. The appraised value of the land alone on a bayfront lot is nearly 6 times greater than any other lot on the block, and the market value may be greater, as these lots are entitled to and insured a bayfront view. It does not entitle them to a 180-degree view or a view across their neighbor's property, but it does entitle them to a view within their property boundaries, just as properties located on the canal are entitled to a water view within their property boundaries. Often, peripheral views are obstructed by walls or fencing, lush landscaping, and or accessory structures in the rear yard. In addition, the desire for privacy may mean that an adjoining neighbor's view across another's property is obstructed through intentional site development designed to promote privacy. In conclusion, staff does not believe there is a basis for the administrative decision to be overturned and recommends denial of the appeal. Also in your packet are plans of the proposed house, the new house, as well as some pictures that I took and some aerial views of the homes. Oh, and I also have a letter of objection I need to read into the record. This is from Susan Blumen, president of the Sans Souci Gated Homeowners Association. To whom it may concern, the Sans Souci Gated Homeowners Association would like to have the following position on record with the City of North Miami. In the situation where an administrative variance has been granted and an appeal has been filed by an adjacent homeowner within the Sans Souci Gated community, the Sans Souci Gated Homeowners Association takes the position that the project under appeal should conform to the current City of North Miami regulations without administrative variance. Susan Blumen, President, SSGHA.
Madam Chair, and I have a comment to make on this letter. Even though it was stated that it's a letter of opposition, I'm not clear as to whether it is an opposition, and the writer is taking the position in opposition based on what it says. So it's not clear to me.
Yeah, I think I referred to it as a letter of objection. I don't want to say that. I think it was meant to be in support of the appellants, but Roland.
I mean, you can take that either way. It takes the position that the project under appeal should conform to the current City of North Miami regulations without administrative variance.
I understand. Okay. Sir?
Thank you very much. Again, Ryan Bayline, offices at 150 West Flagler Street. We're here tonight to outline our position, our client's position, as to why, for 3 particular reasons based in the code, grounded in the code, the variance granted here, the administrative variance granted here, needs to be, at best, reapplied for and potentially reversed. So let me just explain the 3 arguments in broad strokes, and then I'll detail each. The first is that this variance, from the beginning, did not or does not comport with the notice requirements in Chapter 3 of the Land Development Regulations. Number 2, we're going to talk about the process in terms of how, under the Land Development Regulations, or supposedly under the Land Development Regulations, the property went from complying or having to comply with one set of setback regulations to another, or in other words, how we got from A to B. And thirdly, we want to, using the code, explain why the handling of the process, which would be number 2, the 2 kind of overlap a bit, warrants and merits a reapplication of this variance for a minimum of 7 or 8 well-reasoned reasons, the least of which is that the two-prong test in the code wasn't complied with. So let me begin from the beginning. In August of 2012, as best as I can tell, a check was submitted to the city for $262.20. I've looked in the code. I'm not sure how that fee was calculated, but be that as it may, and a paper was signed by the owner of the lot simply stating for 20-foot rear setback variance where 25 is required. So I'd like to provide this to you to the extent you don't have it and, make it an official part of the record.
Thank you. We'll take a look at that.
And I believe that receipt is dated August 8th. Shortly thereafter, I believe on or about August 21st, so 13 days after that, the variance was approved. And from that time, the setback requirement at the rear for that property, pursuant to a site plan or what have you that was submitted, was changed from 20 feet to 25 feet. When I met with Ms. Martin, and she was very, very gracious in allowing me to review the file, there was nothing else submitted other than that receipt and a site plan or a survey and that one-page letter signed and notarized by the owner. When the variance was approved, the city mailed 5 letters, supposedly comporting with the notice requirements in Chapter 3 or Section 3 of the code. One was to my clients. The others were to, excuse me for a moment, Mr. and Mrs. Gotlinski, Mr. and Mrs. Quinn, Garth Reeves in his capacity as trustee, and a letter was mailed to the Condo President Board of the Mallorca Condominium Association, which shares the canal immediately to the north. Soon thereafter, upon receipt, my clients filed an appeal. I believe you have all that paperwork. And my clients were required to engage the services of a professional notice service to notice the appeal of the variance. What then happened was my clients paid $400 to mail out 130 notices of an appeal. Now let's just take a step back here. The city approved the variance and supposedly, under the city's code, needed to notify all adjacent property owners. There are 120 owners within the Mallorca condominium. None of them were noticed. None of them were given the opportunity to appeal or even know that a variance had been applied for and granted. Rather, assumedly, they received a notice that a variance they had no idea about was being appealed. Perhaps some of them would have come to support the appeal of the variance. Perhaps some of them, had they known one was granted in the first place, perhaps some of them would not. But as a threshold issue, my clients, pursuant to a regulation I'm unaware of, were required to spend several $100s to notice an appeal when the city was satisfied with noticing the board president of a condo association. So from a notice perspective, there's a definite incongruence here. And as a basic notice of hearing, uniform notice act under Florida law, the application should be renoticed. The approval should be renoticed. Moving from the notice provisions into the next step, the process. As Ms. Martin said, Section 3-604 contains the provisions for processing an administrative variance. And the important part of 604 is capital B, that says the granting of an administrative variance shall be based upon the following. Number 1, the variance is in harmony with the character of the immediate neighborhood and is in keeping with community goals as they relate to the quality of life. And number 2, the variance will not adversely affect or be injurious to the adjacent uses, immediate neighborhood, and the community as a whole. Taking a step back for a moment, the code has these 2 prongs, both of which have to be satisfied. But unfortunately, before August 21st, or I'm sorry, before the appeal was filed, but after the variance was approved, there's nothing put in writing demonstrating how these two prongs were satisfied. The report and the analysis was prepared after the fact, after the appeal. So I'm not sure if there is an email bank, if there is something I wasn't able to get, if there's internal city computer records, if there are notes, but the point is, there's nothing to substantiate that both of these prongs were satisfied. And I would take the position that staff's analysis doesn't meet that goal either. But the important point is there was nothing to substantiate either of those prongs were satisfied until an appeal was filed, which meant that this analysis, as plain as I can say, was reverse engineered to fit the goal that had been predetermined. Now, I think we need to take a look in going to the third part of our position. And we need to use the analysis and compare it to the process. If we go through the analysis, and I don't want to belabor, but this is very important to my clients, the analysis focuses on the increase in value, whether it's for this lot or others, that could be accommodated by building a 7,600 square foot home, where I believe the current home is about 3,900 square feet, maybe 4,000, I'm not sure, I think that's about right. But what I don't see, and what I have not been provided with, and what frankly I don't think exists, is any documentation that speaks to the second prong of the variance. The variance will not adversely affect or be injurious to the adjacent uses. I saw a site plan submitted. I saw one elevation. I didn't see a context plan. I didn't see how staff, or anyone else for that matter, this board, could make a decision that the massing of that home would not be adverse to the neighborhood, that the volume of that home would be adverse to the neighborhood. I haven't seen anything that says, in terms of a photometric plan, where there won't be spillage onto adjacent property, be it my clients or other property. I haven't seen any reports that indicate, or an affidavit by an architect, an affidavit by a land planner. I haven't seen anything. And one thing I would like to point out is that this seawall, which my clients it's a common seawall, this seawall was accommodating and supporting a 4,000 square foot home. The home that's going to be on this property is almost double that. I think it's very hard to say that a home of this size, a McMansion, or perhaps it's even bigger than a McMansion, if you will, without documentation that this structure will not, the compaction rate of the soil is sufficient, or that there won't be any damage caused by the seawall, by pushing or sliding or what have you. I'm not an engineer. I represent developers all over the state. And these are basic, a context plan, a massing plan, a photometric plan. These are basic documents. So even an affidavit by an engineer, affidavit by an architect, a land plan or something, confirming how prong number 2 is met. And I don't think that what we're asking for is unreasonable or not in the public safety. And when this issue was talked about with the Sans Souci Homeowners Association, the letter that Ms. Martin and the city attorney commented on, we received a copy of it. And this letter, not to do things backwards, this letter goes to number 1. This letter says that it's the Sans Souci Association, Gated Homeowners Association's position that when applicants come and apply for an administrative variance, and it's appealed within the gated community, that their intention and their community goals are not to have these battles between neighbors, conform to the regulations. Because the reality, what we have here, is we have a check that buys you 20% of a setback. And if that's what the city intends, with no findings, with nothing in writing before the approval's issued, we only put it in writing after the fact. If that's really what we have here, and as Ms. Martin says, it's true, bigger homes are being built. then the city needs to change their regulations and just change the setbacks by 20% and remove the administrative variance process. But what we're having here is we have a process that, number one, please don't forget, we believe was not noticed properly. And at a minimum, my clients are entitled to their money back. Number two, we've got this process that was decided on with nothing in writing. And in preparing for this evening, I was talking to a colleague of mine. Long story short, it's not too far-fetched to say, if this process works this way, then on November 1, you have another property owner that applies for a variance like this. And Ms. Martin or whomever reviews it and makes a determination that, okay, this is appropriate. And let's say that's on a Friday. And whoever makes that determination goes home that weekend and decides to quit their job. And someone else is deputized to fill in. And that person is given the file, and they make a determination it's not appropriate. Where's the writing? Where's the paper trail? How do you have two decisions when there's really no findings? And that's really the issue here. In all jurisdictions that I've ever worked in South Florida, and when I say South Florida, I mean West Palm Beach and South, public decisions by public bodies in a quasi-judicial proceeding, when people come before you in first impression, I believe there's 6 criteria in the North Miami Beach Code. They have to satisfy 4 of them. And as part of that process, you as a board make findings of fact. The property is uniquely shaped. The property doesn't meet this standard. The property doesn't meet that standard. The applicant hasn't met a standard. The applicant has not met a standard, what have you. And there's findings in a resolution. We have a decision issued here that requires findings with no findings. And it seems to me that the operative phrase is that if you turned on page 2, it says, we've done this before. If that's the standard, why do we have this process? And it goes so far as to say the Board of Adjustment has done this before, and maybe even more. But I would like to think that this board, takes each individual application on its merits and says this is appropriate, this is not. Approve it in modified form, deny it, something based on findings, based on analysis, based on evidence. But one thing that I know is that there are no writings before this was approved. This was all done after the fact, because I am pretty sure that very few of these get approved, get appealed. It just turns out in this instance that this is not appropriate. And it's not a stretch, it's not unreasonable to ask how a house this big will orient with the existing conditions, will orient with the existing setback pattern in the area, will impact a seawall. Will it be, because it's my understanding in the gated community, in this community, each owner maintains the seawall that they have in front of their boundary, if you will. But if there's a problem and it causes, another property owner, perhaps not my clients, perhaps on the other side, this is something we should have known about from the beginning, because if that's the case, the house is too close. And in some, there's one other thing I want to put on the record to be completely transparent. This house could be moved. The architect and my clients had a dialogue. They could move this house back. I believe it was 2 feet 8 inches, although the architect, you can tell me if I'm wrong, but was told, no, we're not interested. So there's an alternative plan here. And we're not asking to not build 2 stories. We're not asking to build. There's an alternative plan that may be in the best interest of the community. But we don't know what's in the best interest. We don't know what's going to be injurious. Nobody knows, because there's no findings. And by the way, I come from I have a definite objective here. But I'm right. And it works the other way. Had the variance been denied, the property owner would be here saying, why did you deny me? There's nothing in writing. There's nothing justifying the denial. And similarly, if they had said, if the zoning administrator had said, we'll give you 2.5 feet, not 5 feet, where's the rationale? And the problem is you've got the notice, you've got this process which requires going from A to B, which as best as we can tell, was done by paying a check. $262 gets you 5 feet, or 20%, which is the most you can get. And there was nothing put in writing. we are asking this board, and then for all the other reasons, the lack of information, we are asking this board to decide in one of two ways. We request that you quash the variance without prejudice and ask the owner to reapply by providing reasonable information confirming the section 3-604, capital B, that it won't be injurious, that it's in harmony, and I don't want to read them in again. I'll submit them for the record if you'd like me to. Or number two, that you allow our client the ability to, and number two, that you allow our client the ability to enjoy living where they live, knowing that whatever documents in the future get submitted, whatever studies, whatever gets submitted that maybe will confirm these two prongs are met with, that they won't, live in fear that the seawall is going to fall in along the canal. And not to be forgotten, even if you don't reach these issues in Chapter 3, the notice process here was faulty, and at a minimum, the application should be begun from scratch. And I'd like to reserve a couple minutes for rebuttal, or I'm happy to take questions if anyone has them. Thank you. Thank you.
I'd like to open public hearing. Anyone for or against?
I would like to issue the oath to anyone that has not taken the oath that desires to speak this evening on this matter. Please stand. Anyone wishing to speak on this matter, or for that matter, any other matter concerning tonight's agenda, stand, raise your right hand. Do you swear, ma'am, thank you. Do you swear or affirm that the testimony you provide is the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. And anyone wishing to speak on this item may come to the podium.
I'm an architect.
Please state your name.
My name is
and
Scott
address.
Winkle.
I just want to introduce this for the record, too. This would be just in case someone else is
Yeah,
already-
and also, thank you. And let the record, for the record, there was the application by the applicant. That was the document that was submitted for your purview. Thank you. Sir, you may proceed with your name and address. Thank you.
My name is Scott Winkle. I live at 11 Island Avenue, Miami Beach, Florida.
And your association with the property owner?
I'm the architect for
Thank-
Dr. Reinfeldt.
Thank you. You may proceed.
I'm the architect. I did not prepare extremely complex argument. However, I'm expecting pictures to say 1,000 words in this case. One, we followed the city's procedure as was laid out to us. We didn't do anything sneaky. We just did exactly as was given to us. There is a precedent in this area for large homes. I would like to bring some pictures to your attention if I can present it that way. Not only to the house directly to the side of us, but on a similar address at 2095 Northeast 120th Road. There is a house called Palazzo de Mare, which is really a palace. And it's quite extraordinary. I don't think anybody would say it's reducing the value of their property. I would like to bring that site plan and picture of that house to your attention. Is that okay?
Absolutely. Yes, sir.
I think you could probably explain it to them or present it to them. This is the elevation from the scene there.
Let the record reflect that two photographs are presented for the board's review. One is an aerial photograph of the property, the subject property, and the other one is what I take this to be the frontal side
Correct.
of the property.
That basically is our site 1 block over. It's a little larger than our site. If I also may, while you're just, this is the house next door to us, to the south. And this may, since we're doing, this is our house. This should pick that help the Shapiro's.
On the mic. Two other photographs, similar photographs, one aerial photograph of the subject property, and also the applicants that are appealing the administrative variance. That photograph is also included here.
So I think I'll let them look. So given the extraordinary location of the property and it's an expensive property, the tendency is to develop these properties so that the real estate value is like congruent with the amount you spent for it. We've seen this on other sites in the areas you'll see in that picture. Also next door to us, they not only built large, but they also confine our view remarkably. Can I present this evidence as well? Or it's not quite as germane, but it's relevant.
Yes.
Those will be coming your way, but those are the house, the way we are encumbered by the house to the south of us. That house, I measured the other day, it seems to me to be 22 feet 6 inches from the seawall to the house. I don't know if they applied for variance, but somehow they're slightly beyond it. There's a lot of examples, but I think the idea is expensive property. People have a right to develop the property. They don't necessarily have a right to a view over our property, although we've offered to work with them. And we're not really wanting to go there, but we do have a compromise solution that we could live with. We presented it to them, and they were only willing to go along with it if they could have us sign legal documents regarding the landscaping specifics of our property, which we were not willing to do. So we would like to get the whole thing, but we are leaving it open to a compromise solution. There's a lot of details, but I think that's really that's us in a nutshell.
Can you that, if I may, Madam Chair, if I may, because that seems to totally contradict the testimony. Just is it Bayline?
Line.
Bayline? Thank you. It was just stated on the record that they had offered a compromise which was rejected by you, or by...
No, that's not what I said.
That's not what you said?
That's not what I said.
Okay,
I
can
said
you clarify that?
I said, for the record, there's a second option to move the house back. I believe it's 2 feet 8 inches. I was not part of any of those discussions. In
Right.
fact, all I saw was email traffic. But at the end of the day, the decision was made by the architect or perhaps his client to see how the chips fell tonight.
Okay.
But
So,
let me respond
but
just to two other things.
That's still a viable. I mean, from what I'm hearing here is that it's still a viable conclusion, depending on which way this board makes its decision.
I'd just like to respond to a couple other points. For the record, if you go online, type in my name, find out who I represent, I do not represent anyone but developers. I believe development is good. Smart development is good. Some of the largest buildings in downtown Miami, I have been 150% behind. I am concerned in this case at the lack of documentation, massing study, orientation.
Sir, you've already well articulated
exactly.
that point.
But I just want to say that all of the points that we made, the response has been value, value, value. We're not here debating that a big house costs more money, and if you spend a lot of money for land and your land's very valuable, you should build a big house. That's not what we're here debating. We're urging this board to help make some findings that what they're doing is smart development. Boards, whether it be administrative or quasi-judicial, it's Florida law, are charged with making findings in order to bolster the decisions that they make.
All right, sir, with all due respect, I'm going to turn over the the opportunity to speak to the property owner, the subject property owner in this case. Thank you. So, Mr. Architect, are you complete? Have you completed your testimony?
One other small thing, and that is the type of piles they use now.
Can you please speak into the microphone? I just want to make sure we
the
have
type
this
of piles that are used now are called auger piles, and it's a helical drilling, which the concrete is actually pumped into the pile. So
concrete
it doesn't,
injection.
Oh, I'm sorry.
Concrete injection?
Yes.
Yeah.
Thank you.
Familiar with it.
And it's not like banging piles into the seawall.
That's
so
right.
I would say our engineers are comfortable with that.
Thank you.
Hi. My name is Howard Reinfeld, and I swore under oath to tell the truth. And I want to open by saying that I thank the city for giving a variance. I know it's under protest now, but we had all the intentions of working with our neighbors, but I believe the lawyer is not telling everybody the whole story about what happened. We did try to compromise, but they had a contingency that he's well aware of, that we had to sign on a dotted line that we have to get approval by the neighbor to plant trees and do other architectural things of landscaping. Otherwise, they would not allow us to have the compromise. So he didn't tell you that, but that's one item. Number two, he didn't tell you that we had soil testing. Number three, he didn't tell you that we had people that do pilings come in and do a drilling to check the level of the sand. And we had, number four, a person to do the seawall inspection. All of that was following city codes, and we got all approval from the city to do all of that. These he didn't tell you. Number five, he didn't tell you that there are other people in the neighborhood that have built houses that are large on the same type of footprint that go on to the variance, beyond the variance. And if you look at Google, you'll see that the neighbor that's protesting my variance has their property line beyond the variance. So, I mean, you know, so I'm just saying that there are other people that have other houses that are larger than what I have that have beyond the variance. So I think that would be a discrimination not to allow it. But I would say that we are very conscious of what everybody has in the neighborhood, and we'd like to, you know, comply with whatever the city represents and follow all the rules and not make up fictitious things like the seawall is going to destroy and break, because we've had all of that checked, and it's in excellent condition, and the people that would be doing the architectural design and doing the actual drilling would know what to do because they'd have permits. So this we already applied for. So it's not that we didn't look into anything, because that's all confabulation, what he's saying, that we didn't take any precautions. We've all done that. So my suggestion is I'm open to setting it set back a little bit to compromise, but I will not sign a landscape variance that the lawyer is suggesting I do, and the neighbors are trying to bully me to do. So I'm not a closed-minded person. If we get the 5 feet, that's fine. If we don't, I'll be taking a compromise. If I have to even go back to whatever the city says, I'll comply with whatever that is. I'll follow all the rules. But I don't think he's telling you the whole story the correct way. Thank you.
Okay, thank you very much.
If I may, I'm sorry. No, in response,
First of all, the chair is the one that calls this meeting to order. She's in charge, not you, not me.
May I respond?
If she decides that you can respond, fine. Otherwise, I would offer that the subject property owner finishes. If there's anyone here on this side that wants to speak on this matter, and then you can respond, sir. Nothing. Okay, thank you. It's your...
Briefly, sir.
Very
because
briefly.
We need to have
all
board discussion.
What I said was that when I reviewed the zoning file, I didn't see any of those reports. I didn't say that they didn't exist. I said we hadn't seen them. So to make a statement that I'm misrepresenting what was in the file to this board is just not accurate. There were none of those reports, and that's what I said.
Thank you.
Madam Chair, as a point of order, let the record reflect that Mr. Bayline has submitted a document identified as the lobbyist registration for the City of North Miami. And it's including the lobbyist registration affidavit for the record. So.
Thank you. And before we take board discussion, let the record also reflect that Mr. Bondizia is with us. Okay, Mr. McDermott, I know you've...
No, I just a simple question, Madam Chair, through you. Who do you represent, sir? Because in several of you said client and then you said clients, plural.
Mr. and Mrs. Shapiro.
You represent Mr.
Mr. and Mrs. So I'm sorry if I had multiple, use the plural, the singular interchangeably.
Okay.
Yes.
All right.
Mr. Haber?
I'll move over here.
Mr. Bayline,
Yes.
is it your contention that a two-story home would not significantly obstruct their enjoyment of their home, of your client's home?
It's my contention that I don't know if anyone knows that answer, because there's no, I'm not an architect, I've worked enough with buildings, but our clients have a two-story home. And there's no volume study showing under 3604 how the building will fit within the characteristics of the neighborhood, how the home, not to mischaracterize this as an office building or something, how the office will fit within the neighborhood. So how can one say if it will be to a benefit, if it will be injurious, or what have you?
I think I got the answer. The staff now, I have a question.
If I may.
Where I'm going with this.
And before we close this, I do have some commentary to make some clarifications. We're not here to review the plans for this construction. We're here for a setback. Anything done on this property will be done in accordance with city code and the Florida building code. So this talk about the seawall, the footprint, not even relevant. Not even relevant here, because what we're looking at is a setback, which is allowed by code. So the construction, and I know that the attorney had indicated he's not an engineer, neither am I. Trust me that this will go to an engineer, it will be approved, it will go through the permitting process. And it will fail. It'll pass or fail at that time when we cross that bridge. We're not here for that.
My question was more going towards Section 3-604B, which specifically requires the variance will not adversely affect or be injurious to the adjacent uses, meaning the neighbors, essentially.
With neighborhood or what have you. Yeah.
Or the neighborhood. And my only contention is we don't decide whether they get a one-story or two-story exactly. We just make a decision on whether or not giving them a variance will have an injurious effect to the property, and that's really what our decision has to be made upon. And
if I may,
I'm trying to go. Do you understand?
I understand, but the whole idea behind a variance is to take everything in consideration in terms of that applicant, whether or not they were unfairly or their property unfairly impacted them because they had such, and I think it's on page 2 where it says the lot is long but does not have the depth that the interior lots on the block have. So in other words, they're starting off at a disadvantage. So the whole idea for that disadvantage is to come in front of the city, and this was taken care of by a variance. Now, in terms of view, and I hear everyone talking about, is this going to stop them for having the view of the bay? But you're allowed. I mean, if they walk out of their property and they can see through across, that's what their property gives them. It doesn't say that if you look diagonally to the west, to the east, that you're supposed to have a 360-degree view. You come out and you have, property on the bay, and that's what it is. And they already said that theirs is 2 stories, so this is another 2-story. And Joanne, I'm pretty sure that there are, for administrative variance, there are certain criterias that the staff, at least the city, goes and check off to make sure that the gentleman met those criteria.
No, there's no criteria other than what's in the code. We do not have to put anything in writing. We review plans all the time, just like with other plans. If we see things that are not we have to write down. When we deny plans, we write the reasons and what corrections need to be made. When we approve a set of plans in the Building and Zoning Department, we don't write why we approved them. Yeah, we think it's pretty. No, we don't do that. We only write when there's a denial. The land development regulations give us the latitude to approve these types of variances. As a matter of fact, our code was, redone in 2009, and although that administrative variance section had been in there for a long, long time, we had many workshops, we had public hearings. Nobody ever once objected to that criteria being in there or even brought it up. It was like they commented on so many things in the code, but that wasn't one of them that anybody, the opportunity, was then if the homeowners association or anybody wanted to say, hey, we don't like this, we don't like staff doing this, then, that was the opportunity then.
The code provides a very narrow window for the administration to issue an administrative variance. Otherwise, it would be before this board as a regular variance if it was a major deviation from the strict requirements of the code.
And that's what I'm wanting.
So we're talking about 5 feet. We're talking about 20%. Any more than that would have required the regular variance process.
Okay. Ms. Tondreau?
No, but you just answered my question.
Thank you.
Can I make a motion?
Sure.
I'd like to make
Before you do, for the record, I would like to preserve some statements, at least a rebuttal on some of the statements that were presented in case this should graduate to the appellate level. Much was said tonight about the failure of notice, but you notice that the appellant is here, timely submitted a request to be heard, and we are entertaining that this evening. So it's sort of like flabbergasted as to why a notice argument would be made when they're here. Also, letters were received by other property owners in the adjacent vicinity. The notice, I can assure you that the notice was issued pursuant to city code and Florida statute. In addition, these proceedings were also noticed as well.
Right, and you have to understand that the notice requirements are different for a public hearing than an administrative variance. Public hearing, we always require the 500-foot radius, mailings.
And if I just may one more, if I may first finish, Madam Chair. Very eloquently, Mr. Bayline indicated that the city did not meet certain reports or requirements. However, the burden of proof is not on the city. As the appellant, the burden of proof is on the appellant to show an injury, an actual injury concerning the approval of this variance. And I don't think that's been done tonight.
We have a motion, and I believe we do have a second.
Could I ask a question?
Sir,
No,
I think
not
we
to let-
really...
due to a lack of evidence that's provided by the appellant, I make the motion to deny the appeal.
I second.
Wow. Motion by Mr. Haber and seconded by Ms. Tondreau. Roll call, please.
Ms. Phillip,
Yes.
Mr. Haber,
Yes.
Mr. Mardi,
Yes.
Ms. Tondreau,
Yes.
Mr. Mondesir,
Yes.
Mr. McDermott.
Yes.
Okay. Well, thank you, and
Thank you.
your appeal has been denied, and will they be heard in front of council? Is that an option? No, this is it. All right. Next case, V-11-12, IHOP Restaurant.
Come to the microphone, state your name and address for the record.
Good evening. My name is Andy Poschel. I'm the Director of Development and Construction for IHOP Restaurants. The address is 13650 Northwest 8th Street, Suite 103, Sunrise, Florida, 33325.
Okay, this is a petition for a variance to Article 5, Section 5-1505 of the Land Development Regulations to allow 2 additional identification signs when only one identification sign per street frontage is permitted in the C2BE district. Staff recommends approval of the petition to allow 2 additional identification signs on the building. The applicant is constructing a new and larger IHOP restaurant at the subject site, which will no longer be franchised, but corporate-owned and operated. Article 5, Section 5-1505 permits one single-face identification sign per street frontage, the size of which can be up to 1 square foot of signage for each lineal foot of building frontage and not exceeding 150 square feet. The applicant is permitted by the LDRs to have one identification sign facing Biscayne Boulevard and one facing in the rear facing Northeast 18th Avenue. The applicant wishes to have an identification sign facing Biscayne and an identification sign on both the north and south elevations of the building, but not one in the rear. All three proposed signs will be illuminated. The sign proposed on the south elevation is 71 square feet in area. The applicant stated that the sign will identify and be placed over the entrance to the restaurant, which does not face Biscayne Boulevard. The building is situated so that the entrance is on the side of the building facing south. The sign proposed on the north elevation is 30 square feet in area. The applicant stated that this sign is necessary to identify the restaurant to southbound vehicular travelers. It is staff's opinion that the signs are attractive and not overbearing. The sign on the north elevation is relatively small in comparison to the size of the building and will add some aesthetic value. In addition, staff finds that it is customary for a business to have an identification sign over the main entrance to a building and therefore understands the need for the additional sign on the south side of the building. In your packet, you have photographs of all the proposed signage, as well as the site plan and some other plans, but the site plan that was approved for the new IHOP restaurant.
Thank you. Sir, would you like to tell us about your item?
Well, the existing building, the existing IHOP building that we had.
Please state your name and address for the record. If you did,
Okay.
I apologize.
That's okay. The existing restaurant, the A-frame that was located there, was 45 years old. Our lease was up, and we basically decided to buy the property. It was a franchisee. We purchased the property and decided to basically level the old building and build a brand new one. It's 1,300 square feet bigger than the existing, and it'll hold 150 seats. The other one was only an 80-seat restaurant. We didn't want to lose the property. I think it's well located there, so it was worth us buying the property and building a brand new restaurant.
One of your clients.
One of the reasons we have a main sign on the front facing Biscayne. One of the things we want to do is locate one on the north side. The reason why is when you come from the north, going southbound, the landscaping basically blocks everything. You'll see the restaurant when you're right on top of it. That's why we want to see if we can, our red channel letters will go here. At least you can see it when you're going southbound. It gives you a heads up so you can turn on the turn lane, which we have a turning lane into our restaurant. Going northbound is almost the same thing. You'll be able to see our sign over our front entrance. Sorry. You'll be able to see our sign over our front entrance, but you can barely see our sign facing Biscayne Boulevard, which that will basically look like this. Those are the bigger pictures that what you have there. This will be our main entrance facing south, facing Biscayne, and we have a pole sign also on the and this is the north elevation would be our channel letters that you'll be able to see when you're going southbound between the trees. Yeah, we don't want to cause any accidents by people just looking at it and then all of a sudden hitting the brakes and trying to turn in. Hopefully we're under construction right now. I don't know if you saw on this one. The shell is already up. We already started installing windows. Drywall's being hung tomorrow, so we're looking for first week in December to be open and be open before the holidays. And at least we're going to hire approximately about 80 people for the restaurant because we work 24 hours, never close.
Yep.
So we have 3 shifts. So in between all 3 shifts, we're going to hire about 80 people.
We got 4 clients. We got all clients here.
I mean,
Our intentions were to stay in the market.
It's okay. So you sold your
You
story.
got customers.
Oh,
No.
okay.
Yeah. But you gotta bring back the buckwheat pancakes.
I'll find out you about that. I'll find out.
Thank you. Okay, I'd like to open public hearing. Anyone for or against this item? Okay,
Madam,
public.
Can I make the motion?
Board discussion?
I'd like to make a motion.
Actually, I have a quick question. For on the north side, you guys say you're doing channel letters?
Yeah, we have channel.
Is that-
we only use two types of signs. Basically, our cabinet sign
Mhm.
with the IHOP, and then the red individual channel letters.
Did you guys do a study? Is there a reason why channel letters on the north side, not the?
Well, IHOP corporate only allows us to use that. Either
Okay.
the cabinet sign or individual red channel letters. And that's the color we have to use. We can't use anything else in that.
It's a franchise requirement.
It's a franchise requirement. It's a corporate requirement for IHOP.
Any
Make a
other
motion.
board discussion?
Can I make a motion?
Yes,
Once the public hearing
Hearing
is
is
closed.
closed. No, we,
Okay.
it's board discussion, and since they apparently have nothing else to discuss, Mr. McDermott, you did want to make
I move for approval.
I second.
Okay, we see we're fighting for this. All right, roll call, please.
Ms. Phillip,
Yes.
Mr. Haber,
Yes.
Mr. Mardy,
Yes.
Ms. Tondreau,
Yes.
Mr. Mondesir,
Yes.
Mr. McDermott.
Yes.
All right, you've been approved.
All right. Thank you very much.
Thank
Have a great evening.
Lord, sir.
Good luck. Said before the holidays, huh?
And listen,
For the
hopefully,
holidays.
See ya.
We wish you a lot of luck.
That's from my house. All right, next case. V-12-12 North Miami Islamic Center. Is the applicant here?
Yes.
Before we
Uh-huh.
commence, everybody took an oath?
No, but
Okay.
you can do it again.
This is
I did when I become a citizen, but I can do it again.
anyone wishing to speak on this item, stand and raise your right hand. Anyone whatsoever. Please stand.
Please stand.
Okay, thank you. And raise your right hand. Do you swear or affirm that the testimony you provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. May all be seated.
All right. Would you like to tell us a little bit about your...
Oh, wait a minute.
I'm sorry.
He can state his name and address for the record first.
My name is Dr. Muhammad Mizan Rahman. Property located is 560 Northeast 129th Street.
Okay, thank you. This is a petition for special exception use pursuant to Article 4, Section 4-202, and Article 3, Section 3-504 of the Land Development Regulations to allow a religious institution in the R2 district. Staff recommends approval of the petition with the following conditions. 1, that the chain link fence along the front property line is replaced with a galvanized metal fence. 2, that the roof and fascia of the existing residence is cleaned and painted if needed. 3, that the landscape plan is revised to include staff's recommendations regarding the perimeter landscaping, and the swale is improved to include ligustrum trees every 15 feet. 4, that the sidewalk along the south property line, which is enclosed and encumbered by the applicant's fence, is abandoned by the applicant or the fence moved. 5, that an affidavit is completed by the owner of the property attesting to staff's condition that the house on the property will only be occupied by the pastor of the church as an accessory use to the principal use. And 6, that all services and activities shall take place inside the building unless a temporary use permit is obtained for outside activities that are part of a special event. The property is a 33,000 square feet of land with a 1,587 square foot residence situated at the front of the property and a 1,200 square foot building to the rear of the property that is below the grade of the land. The property was once part of the adjacent church property at 12800 Northeast 6th Avenue. The property has been underutilized for many years, with only the residence being used as a rental property. The applicant wishes to renovate the property for use as a religious institution and pastor residence. The building in the rear, which was damaged by a fire years ago, will be used by the congregation as the house of worship. The applicant has applied for building permits to repair the roof and the electrical. There are 40 members currently in the congregation that are expected to frequent this location. The most important day of the week for services is Friday, and the hours of operation will be 1:30 p.m. to 2:15 p.m. Prayer services where smaller groups may congregate are also held on Saturday through Thursday at the following times: 30 minutes before sunrise for 15 minutes, 2 p.m. to 2:15 p.m., 5 p.m. to 5:15 p.m., 5 minutes after sunset for 15 minutes, 1 hour after sunset for 15 minutes. The parking required for religious institutions is 1 space per 100 square feet of floor area. Thus, the applicant requires 12 parking spaces, and the proposed plan provides for 13 newly constructed parking spaces. Since the property is adjacent to residential uses, an appropriate landscaping buffer is required by the LDRs. Although there is more than sufficient landscaping in some areas, staff is recommending changes to include ligustrum trees on the swale, which is currently barren, and changes to the perimeter landscaping in order to provide a neater, cleaner look, which will include replacing the existing ficus plants with a new, low-maintenance solid hedge, as well as the required trees. It is staff's opinion that since religious institutions are permitted by special exception in the R2 district, they are deemed to be an appropriate use in the district. In addition, the subject site is large enough to accommodate the use and provide for the required parking and landscaping. Article 3, Section 3-504 specifies the following standards for the issuance of a special exception. The use is listed as a special exception in the district. The use of religious institution is listed as a special exception use in the R2 district. B, there is adequate provision for access facilities, adequate for the estimated traffic from public streets and sidewalks, so as to assure the public safety and avoid traffic congestion. The existing entrance from Northeast 129th Street will be widened to 24 feet to provide for adequate access to and from the facility. C, there are adequate parking and off-street loading spaces if needed for the anticipated number of occupants, employees, patrons, and the layout of the parking is convenient and conducive to safe operation. There is adequate parking proposed for the anticipated number of occupants according to the standards specified in the land development regulations, and the parking layout is conducive to safe operation. D, there is suitable landscaping or fencing alongside rear lot lines adjacent to residential uses or zoning districts. There is suitable landscaping proposed for the most part. However, staff is recommending certain changes and replacements to the landscaping and fencing, to which the applicant has agreed. E, the proposed special exception is reasonable in terms of the extension of public services and facilities. The use is reasonable in terms of the extension of public services and facilities. And F, the special exception will constitute an appropriate use in the area and will not substantially injure or detract from the use of surrounding property or from the character of the neighborhood. The proposed use is an appropriate use in the area as religious institutions and schools are considered residential uses. The use itself should not injure or detract from the use of surrounding properties. You also have plans for this project in your package.
Okay. Sir, would you like to speak on your item? Sir? Anything would you like to add?
I think we submitted all the necessary papers and drawings and whatever the recommendations we will abide by.
Is he the right author of that letter?
Oh, I'm sorry, that we received a letter, in a letter of objection to the petition, from Dean Fujita, 547 Northeast 130th Street. I would like to take this opportunity to express my concerns about the petition for the North Miami Islamic Center. The ordinances in question were no doubt put in place to preserve the integrity of the residential community. I strongly believe that any establishment that has the potential to produce excess noise levels, increased traffic volume, and car parking issues would negatively affect the neighborhood. And my largest concern is the contagion of lowered property values. Also, as a religious institution, I assume they are tax exempt and would not be contributing to our tax base, therefore increasing the burden of the taxpayers. In conclusion, I do not support petition B1212.
Madam Chair, with your permission, if I may rebut certain sections of this letter in the event of an appeal. If I may proceed?
Sure.
Thank you, Madam Chair. This letter came in without any attachments. I take them to be a presumption on the author's part. It lacks any evidence to support the conclusions reached. The complaint about noise levels is already addressed in a separate code section, and that noise level is a violation that can be caused by a mosque, a synagogue, a church, or just a rowdy party from a residential dwelling unit. Also, the parking is a non-issue because the property already contains sufficient parking. So that is my rebuttal.
Thank you, Mr. Anton. And the gentleman, would you like to?
You have any question?
If you have any questions.
If you have anything else you would like to
as far as the noise level is concerned, that is, the number of people in the property is very minimum. Regularly, probably 10, 15 people. Friday will be maximum 50 people. And it's the church is on the back of the property. It is almost an acre lot. I don't think it should be noise. And the structure of the building is, even if you shout even inside, no noise will go inside. I think all those who are familiar with the property, you can ask them. As the noise is concerned.
Thank you. Public hearing is now open. Anyone who would like to speak for or against, please come up.
My name is Nereida Medina. I live on 127 and 5th Street. I know this neighborhood very well. I live over 15 years in this neighborhood. And one of the reasons when I moved to the North Miami area when I was going to buy a house, I remember the VA gave me a list of the housing in the area. And I went all over some houses that were available for veterans. And when I run over that house, I stopped by, even it was not on my list, and I ended up buying the house. But one of the reasons that I moved to the North Miami instead of staying in Miami Beach, where I live over 13 years, it was that it's a quiet area to live. And if you see around the city when there is a lot of things going on, especially political things going in Miami, like you go into the Southwest and you see the Cuban community, when there's something wrong over there, everybody goes to the street and eats the cows. When it happened in the small Haiti, little Haiti, not too long ago, like 10 years ago, in 79, I even work as a freelance nurse, and I got some patients who were hit over there, and some of them were suffered different type of damage due to that revolt that it was in 79. But those things doesn't happen in the North Miami area, and not even in the North Miami Beach area. That's one of the reasons I moved over here, aside from the traffic and things. Now, I wanted to bring you a study conducted by the Syracuse University of New York not too long ago, but you can see it in the internet because these days everything is available in the internet. My printer just ran out of ink, and I don't want to bring it like that. but it's on the internet and Google's under Syracuse, and it says Muslim and value of the properties. Okay, this study was conducted mostly in the United States from the success happening in 9/11 up to this date. It shows that every property within 1,000 feet of a Muslim center has the value of the property goes down 17.1%. If you are within 2,000 to 5,000 feet, it goes down like 5% of the property. My property happened to be within 1,000 feet of this Muslim center. You know, why do I have to go to take a devaluation of my property more than the actual devaluation that we have? When I see and I live in this property, and I go to Publix, and I go to President Supermarket, I come here to the city sometime to the other section of the city. I go to the church around here, and I don't see no Muslim members in this community. I have seen one lady once in public. That's it. No more Muslim. The address that this guy give over here is an address that he just got that property, because the address that he provide you is the other 560 Northeast 129th Street is where this church or center is to be placed. Now, I don't know how good are you, because some people talk about Muslim and they have different concepts, and most of them are wrong concepts, okay? You need to know about the Muslim religion. I respect the Muslim community. They have the right to practice their religion.
I hear you, ma'am. Is there anything specific?
Yes, ma'am. Aside from that, I think that some of the points that they have over here, in which you said there is a church over there already, because he said the part of his temple that goes in the back of the area that he bought is 128th Street, which is a cul-de-sac street, and the back of that cul-de-sac is where the property is. Now, the other side of the property, looking to the 6th Avenue, that property is a church. It's a Christian church, happen to have a daycare center that is facing the property where his temple is going to be. You know, I don't know where do you live, but I live here in the United States, and I'm aware of the anti-Islamic people, and I'm aware of the anti-Americanism sentiment of some people. Then I don't see how are we going to deal with that in the future here, because that would be an issue for us, the one who live in this community.
I hear you, but right now we want, if you're speaking against or if you're speaking for, it has to deal with what the applicant.
I'm speaking against having that in the property, because this is, I'm sorry, I'm kind of dry. This is a community that has already a couple of churches inside.
Okay, all right then.
All right.
Thank you. Anyone else? For or against? Sure, come to the mic.
Thank you. My name is Noor Amin, and I preach in one of the masjid in North Miami Beach. It's just newly it's been there.
Please state, I'm sorry to interrupt, please state your address.
I'm sorry?
Your address for the record.
Address?
Yes, sir.
My address is 1359 Northeast 127th Street, North Miami, 33161, apartment 211.
Thank you, sir. You may proceed.
Okay. So in North Miami Beach Masjid, you know, when it was started like 2 years ago, I wanted to buy a condominium from there in that building. It's a high-rise building, and it was like $35,000, but I didn't have money at that time. Now I think within 2 years, if you go there in that building, it's now more than $70,000. Just a one-bedroom apartment condominium. So, madam, what she has said, you know, I think is not correct in every aspect. And different thing is the Muslims, whatever is the blame for whatever she brought it here, I think it's not same in every case. It's not. We should not have take the same idea that what has been in 9/11 happened on what has been in Afghanistan or Pakistan or India or Pakistan or Bangladesh happened. It is not in every aspect. We cannot take it in the same level. Thank you. That's all.
Thank you. All right. Public hearing is closed. Board discussion.
Madam Chairman, that property has always been a church.
Yes.
Okay.
Sometime in after school.
Hmm?
And after
Sometime in
school.
after school.
Yeah.
I remember
Sometime
way
in
back.
after school.
Mhm.
You know, I drive it by that property all the time, and it has been the most run-down, raggedy property you could ever look at. From what they're going to increase the property values in this neighborhood, because if you look at what their proposal is with the landscaping that they're going to have, with all the improvements they're going to make, I would think they were going to improve that neighborhood. I mean, they're going to take a lot that has been an eyesore in this community for a long time. We had vagrants living in that house. We've had all kinds of things going on. We had stolen cars that were found on that property because you can't see it from the street in the back. I know that many of these gentlemen are here have businesses in North Miami. They're paying North Miami taxes. They're good citizens of our city. And I just think that it would be a good thing for this to happen.
Thank you. Anyone else?
It is sad anyway that we have to hear about the 9/11 stories, and I want you to know not everybody is ignorant. We know in all people there are good and there's bad, and it is really being narrow-minded when somebody see one person carrying one religion and to think that everybody is this and that. And I can understand what you guys are going through, because when they see me, they always say voodoo. So it's the same stigmatization that we have among people that are intolerant and ignorant. I think it's a good thing. The property has been there, has been doing exactly what you want to do in it. It's not going to be any major changes.
Yeah.
As a matter of fact, from what I hear from
Yes.
my colleague, they used to steal cars and put them there. So if the location is occupied, it will be a better thing. Less work for our police officers and sure for our citizens.
Excuse me. As a matter of fact, police officer in the pre-hearing asked me to additional light so that they can look in the back.
So
we incorporated in that drawing.
good. I think it's a good thing.
Mr. Haber.
Yes. I reviewed your plans. I'm consistent across the board with everybody who applies for the variances. And I'll ask you the same question about security. Do you guys have any plan to put up cameras or any security?
Yes, it will be 24-hour surveillance. And right now, we don't have the electricity done, so we put a security guard so the place is
Great.
protected.
I think that's more than what's required. That's excellent.
Yeah, I'd like to make a motion, Madam Chairman, unless Mr. Mondesir has a comment.
Yes, I do. I would like to basically echo Mrs. Tondo's statements about the narrow-mindedness of people when it comes to different groups. But my question is, what was the property before?
It was a church.
It was a church before.
Then a church again.
It's always been a church for many, many years.
So
Or church
basically, this
property.
isn't anything out of the norm.
Yeah.
As a matter of fact, in this city, any religious institution may exist not only in an R2 as this is zoned, but also in an R1, which is even more restrictive. So it's a foregone conclusion that they're appropriately zoned, and whatever the denomination happens to be.
Yeah. So, Madam Chairman, I'd like to move that we approve the applicant.
And I second it.
Okay. Roll call, please.
Roll call.
Thank you.
Ms. Phillip,
Yes.
Mr. Haber,
Yes.
Mr. Mardi.
Oh, I'm sorry. Mr. Marty had to leave.
Yeah.
Oh, okay. Ms. Tondreau,
Yes.
Mr. Mondesir,
Yes.
Mr. McDermott,
Yes.
Thank you very much. Thank you very much. Thank you.
Thank you very much.
Congratulations, gentlemen.
Thank you so much.
Thank you. Thank you, John.
Councilman, thank you
All
very much.
right.
Thanks.
Any old business?
I'm sorry?
Oh, no. Any old business? Board? Okay. New business? Ms. Chandra?
Yes.
I think you had something.
Yes. Since many of us, or the big majority of us, are new appointed to the board, I would suggest that we do go ahead and do elections to designate chairperson of the board. And not today, but in the next agenda, we can go ahead and have things set. I don't know what are the regulations here in order to have.
I would imagine there's a cycle for that.
The only regulation is found in the Board of Adjustment section of the Land Development Regulations, and it states that once the chair and vice chair are voted by the board, the term will remain in place for a year. So I believe the chair was I would have to, ascertain this, but I believe it was December. So that would be her term would end naturally in December.
December 2020.
But your election, you could hold your election pretty much at any time, but it will be effective.
Well, the next meeting wouldn't be till December anyway.
Okay, so it coincides with December. So you could have your election, say at the next meeting, effective January.
Gotcha.
Once the cycle ends.
So yeah, so it would be at the end. I would recommend at the just prior to adjournment, a vote, and it will become effective at the next subsequent board meeting.
Very good.
All right.
So yes, we could entertain that at the next agenda.
Okay. So can I make a motion if there's no discussion?
No, we're going to automatically.
Yeah,
vote on
we'll do
the-
that automatically. We'll do that. We'll do that automatically, and it'll give the board an opportunity to then vote to re-elect the same chair or vote for a new chair.
Very good.
Quick, what's the protocol as far as electing someone
For candidates.
or candidates?
Okay.
Nominate.
Nominate
it's
yourself.
within your
Made that
purview.
same night, or you take
Yes.
the
Well,
profile
it-
needs
it-
to be given.
In the past,
every
it's been
board.
done just prior to adjournment to be effective at the next upcoming, whether that's January or February, whatever the next meeting is, it'll be effective. That person that was elected by the board would then take over the proceedings as the
Are
chair.
we allowed to discuss elections amongst ourselves or no? Is that a violation of the sunshine law?
I would,
Right here, you can.
air it
Yeah.
out. This is,
Well, no, I meant outside
He
of the
means
meeting.
outside of the meeting.
No campaign.
I think that's a tricky one because it's a
Okay.
quasi.
Is
It's a
that,
quasi.
yeah.
So
any,
Well,
any,
I
yeah,
don't think
discussions between you and me,
Okay.
and I mean that individually, we
Okay.
could have at any time. I am your counsel. Discussions amongst yourselves is supposed to be a no-no because this is a
Right, it's violation.
quasi-judicial
Okay.
board, and you don't want to be charged with ex parte communications. and all
No.
that
You
kind of
know
stuff.
I'm busy, some people now, they will be more than happy to do and charge us. So we're not talking.
So it would be something. It's a democratic process. I urge you to do it in all transparency.
Transparency.
Yeah,
Very
just,
good.
take into consideration what's in the best interest of the board and the public.
Of course.
Exactly.
You know.
Yes.
Yeah.
Correct.
Sure.
Anything else?
No.
Okay, do I hear a motion for adjournment?
I second.
All right, thank you.
Thank you and good evening to all. Thank you, sir.
Thank
Nice seeing you.